The President, please be seated. The court is now back in session. Just now, there was a request to the chamber to clarify the procedure for presenting the documents before this chamber. To be precisely clear to all parties involved, following the deliberation of the judges of the bench, the chamber wishes to advise the party in relation to the objection as well as the submission of documents to be put before the chamber, and the chamber wishes to hand over to Judge Civil Cartwright to provide guidance to all parties in respect of this matter. I now hand over to Judge Cartwright.
Thank you, President. The Chamber notes that there are two matters on which it needs to give guidance to the parties. These two topics are discussion of the admissibility of documents, and separate and independent from that is the presentation of key documents. The Chamber's guidance refers first and solely to admissibility, and then I will move to issues concerning key documents. The Chamber notes that the OCP and the lead co-lawyers have made oral submissions on objections to the admissibility of documents. It notes also that Ieng Sari has responded orally, but that counsel for him has referred to the making of submissions in writing. The Chamber would like Mr. Carnavas to confirm now, if that's practicable, if the written submissions are a reference to the annex to the email circulated today. Mr. Carnavas.
Thank you. It deals both with the annexes that the prosecution submitted from yesterday's presentation and, of course, what was circulated by us this afternoon, which, of course, we are in the process of double-checking now in light of the remarks that were made and decisions that have been taken.
Can I further clarify then, how much time would you need to finalize this process?
Well, in light of what we heard this afternoon, we're in the process now of double-checking. We thought we had checked everything. Obviously, we missed some things. So we think that by tomorrow we should be able to have that completed. We do have one issue that is unclear. For instance, it was mentioned that Judge Laverne showed a document to a witness and nobody objected. Well, with all due respect, we cannot object to Judge Laverne showing documents to witnesses. And, of course, the question is, what becomes of that document once it goes from a D to an E? Is it deemed admitted, or is it out there in the stratosphere for us to then try to move for its admission? And so we're having, so that's one of the documents. But we hope to have a redacted and hopefully a proper annex by tomorrow.
Well, the I note that that's a rather subtle way of saying you wish to object to the document. Please deal with that in your written comments, please, Mr. Carnavas. And the Chamber would like to take this opportunity of thanking you for the work that you have put in and the preparation that you have done to be ready to make your oral presentations and respond thus far. Thank you for that.
Thank you. But, Judge Cartwright, I may not necessarily want to object to a document, but I think the Cure Sampon team has filed submissions as to what becomes of the document. Once it's shown, either by a judge or by a party to a particular witness, are we to assume that the document is, or at least a portion that was shown, already admitted, or is there still a need for the party to move for the admission of that document? And if it comes from a judge, obviously the presumption is that the judge wants the document in. And so, and if I may, and I hope that I'm not testing your patience, but at the ICTY, for instance, simply because you showed a document to a witness, that document would not necessarily come in. One would still have to make an application. And normally only the portion that was shown, and if you wanted other portions, you would have to make some sort of a submission as to why those other portions were not shown or why they're deemed necessary. So for us, it's a little bit unclear. So if the trial chamber, it need not give us an answer today, but at least notify us so we are aware in the future of how to deal with those documents. But I certainly don't feel like standing up and objecting to a document that Judge Laverne is submitting, although I am tempted at times. But be that as it may, I think the judge is entitled to ask whatever questions, however objectionable I may find them to be. But that's their prerogative. It doesn't necessarily mean that the judge is not cognizant of the fact that they may be asking a question that perhaps presses the limits as to whether it should be an appropriate question or not. But I'm speaking from my own system.
I see. I think we see your various points here, Mr. Carnavas. However, we're dealing now with objections to the admissibility of documents. And if no objection is made to a document presented by a judge, then that is the end of that issue. So responses are a different matter. So I hope that assists you to some degree.
It does. It does. Thank you.
Mr. Carnavas, you certainly have until tomorrow to finalise the written portion, and as I said, the Chamber is grateful to you for the work that you have put in. Now, the next issue on objections to admissibility of documents is this. The Kir Sampon and Nguyen Chia teams have both indicated their unreadiness to make oral submissions objecting to the admissibility of any documents. Now, we do note that their respective clients have been hospitalised in the last week. However, and moreover, that the trial chamber brought forward the date for dealing with these objections to the admissibility of documents. Nonetheless, this has been an issue available since December of last year, and so the Chamber has decided that the Kir Sampon and Nguyen Chia teams may file any objections they have to the admissibility of documents in writing by Friday, the 8th of February. All parties will then have the opportunity to respond by Friday, the 22nd of February. The Chamber will then make its decision concerning objections to the admissibility of documents, and that will conclude this process. The dates are Kyo Sampon and Nuon Chia teams by the 8th of February, and all parties may respond by the 22nd of February. Is that right? We now move to the second independent topic, which is the presentation of key documents. The Chamber would like to remind the parties of the purpose of the hearings which have been dedicated to the presentation of documents considered to be of particular relevance to a specific segment of the trial. The first is that it gives the parties the opportunity to emphasise documents that they consider to be important to their respective cases. And the second purpose, which also answers the Kyo Sampon's defence concerns articulated earlier, is that the hearings are dedicated to the presentation of documents and are aimed to ensure a greater measure of public accessibility to the documentary aspect of the trial, meaning this gives a chance for the public to hear a summary of what these key documents are about, and further giving an opportunity to those parties who seek it to highlight for the Chamber key documents considered, as I have already said, to be particularly important to specific segments of the trial. Whenever a document is presented by any party as part of this hearing, the accused will also be permitted to comment on the document if they choose to do so. And I refer, for example, to Memorandum E170, dated 9 February 2012. The Chamber notes that on a number of occasions, some of the accused have declined to comment on documents presented during such hearings, arguing that they intend to exercise their right to remain silent. While no discussion on the admissibility of documents presented during this stage is to be allowed, unless the issue of admissibility has not previously been discussed or ruled upon, it's clear that the Chamber has never prevented the accused or their lawyers from discussing the relevance or the probative value of the documents. It's been indicated on a number of occasions, for example, CE 233 paragraph 3, and I quote, "The time allocated to the defence includes the opportunity for the accused, where sought, to comment on any documents presented or previously put before the Chamber during this trial segment." Now that refers in general to the purpose of the portions of the hearings on presentation of key documents. The Chamber notes that the OCP has begun this process and that the lead co-lawyers have indicated that they will be ready to make their presentation shortly. In order to clarify the procedure in relation to key documents from this point on, it seems most efficient, given the inability of some of the parties to be ready to present their key documents, to ask the OCP to continue with its presentation on the movement of population phase 1 and Tulpo Tray, then on the movement of population phase 2. Then the lead co-lawyers will be asked to make their own presentations on those topics. That leaves then the question of joint criminal enterprise and the roles of the accused. And I think, President, we were going to propose that those topics be presented also by OCP if they are ready to do so, and the lead co-lawyers. That then gives the defence teams ample time to be ready by when we resume these hearings on the presentation of key documents, and the Chamber will expect them to be ready to present their key documents or to make such comments on the documents as they wish to make. So the question is to the OCP, would you be ready to proceed to joint criminal enterprise and the role of the accused when we have completed the movements of population and Tulpo Tray?
Judge Cartwright, thank you. Can I answer that with a very simple answer, which is no, but can I explain the position, please? As the trial chamber will know, requests were made last week to the OCP in respect of the documents presentations that the trial chamber has heard in respect of military structure and the presentation that I'll be giving together with my national colleague in respect of Force Movement 1, Tulpo Tray and Force Movement 2. Can I explain, please, Judge Cartwright, that in taking the notice from the court last week to prepare for these documents, a team was established by the OCP to prepare this presentation for this afternoon, which is not uncommon, I accept, by all counsel in this court, significant and substantial work, literally from the time notification was given last week through to today, including substantial work on both Saturday and Sunday to prepare this presentation. Can I say this, that the OCP is of course mindful of the time constraints that the court is under. We are mindful of the need for court time to be utilised properly in the presentation of documents to the trial chamber. We have discussed this very topic that you raised, Judge Cartwright, within OCP over the last few days, and the position is that we are not able to present within the time frame that you have suggested, but we are certainly willing to start preparation now to present such a presentation to the trial chamber, but we do ask for some forbearance in terms of time. The presentation on the role of the accused is, without a shadow of doubt, the most important documentation that the OCP will present. Can I say this? Preparation has already started on this. It is ongoing preparation. I can tell the trial chamber even this, that certain of my fellow other counsel have been assigned portions of that presentation. They have started work on the presentation, but we do ask for more time. Can I please not be tied on what the time request is, as I haven't discussed this with the national and international co-prosecutors. I know that they would be willing, I'm sure, to clarify a request effectively for more time tomorrow morning, and I can communicate that through to you, Judge Cartwright, tomorrow morning. So, in summary, we are not ready now. We are working on it, but we would very much appreciate some time to properly prepare for this presentation in order that the trial chamber has, I hope, a reasonably polished presentation rather than one that is prepared in haste. Thank you.
Well, thank you very much for that indication. This was the purpose of making the inquiry. The Chamber will await your indications as to how much time you need to be complete in that presentation, and will then rule on that aspect. But what the Chamber has not done as yet is to thank the prosecutors also for the work that they have put in being ready for the objections to the admissibility of documents and also to the presentation of key documents. We appreciate that we've put a great deal of pressure, and we, as with the Yang Sari team, appreciate the effort that you have made. So for the moment, we will proceed with the presentation of key documents on the Movement of Population Phase 1, Tulpo Tray, Movement of Population Phase 2, followed by the lead co-lawyers, and within the next few days, following your indication to us of how much more time you need, we will give a time frame for the remaining topics. And then I am reminding defence teams that they have a lot of work ahead of them, because we will expect them to be ready to respond and or present their own key documents. And sometimes it will be at quite short notice, depending on health issues and other matters. President, I hope that we have covered everything that you discussed during the afternoon adjournment.
Thank you, Judge Cartwright. Defense Counsel, you may proceed.
Thank you, Mr. President. I would like to simply clarify a point in what I said in the event where I wasn't clear. I note the decision taken by the Chamber today, but regarding the mix-up, we feel, and the words that were quoted by Mrs. Cartwright, Judge Cartwright, in paragraph 4 of Memo 170, that was the cause of the mix-up this morning. The kind of hearings that we are dealing with in these memos, as stated in paragraph 4, this hearing does not have to do with admissibility of documents in view of having them tendered into evidence. No time was allowed for responses by other parties. On this basis, we had envisaged that there would be hearings devoted to documents. I'll try to slow down. I'm having problems. I'm speaking very fast. Paragraph 4 of Memo E170. This hearing does not have to do with admissibility of documents in order to have them tendered into evidence. No time was allowed for responses by other parties, and that is why we always envisage that such hearings should be organized. And our position, as I have pointed out sufficiently, is that we understood that the accused were those who had to make comments and not defense teams. That is the cause of the mix-up, because after reading your memos, we did not quite understand. We crave your indulgence for not having paid sufficient attention to what you stated in the memos.
President, I'd like to give the floor to Judge Lavange so he can respond in French to the French-speaking counsel, so that it is better for you to understand it. Judge Lavenge, you may proceed.
Oui, merci, Monsieur le Président.
Thank you, Mr. President. I am not quite sure I am in a position to respond correctly. I just want to be sure that the position of the Chamber is clear to all parties, including Keo Sampan's defense team. Is it clear? Of course, today the position is a lot clearer than in the past, a lot clearer than what we read in the memo. Our position was predicated on what the Chamber had stated. And if that is the case, we would like to have to respond in hearings regarding presentation of documents. That was the purpose of what I stated. Of course, I would like to point out that in the memos in question, it is stated that whenever documents have to be presented by parties during hearings, parties may make remarks on such documents expressly. It is stated expressly. So perhaps what you're saying is that you would like to also present documents. I don't want us to prolong the debate, but our position was quite clear and was made so on several occasions. Perhaps there are problems with translation. Our position has always been clear. It appears that my learned friend Veken explained why we were participating in such hearings, and on that occasion, the clarifications were not made as they have been expressly made today. We have the accused, indeed, but the accused have defense teams. So, in light of the paragraph I have just read out, we did not understand that the Defense Counsel had to make responses, and I'm referring to paragraph 4 of E170. Now we have understood the position of the Chamber clearly.
President, we only have a short period of time for today's proceeding, so it is appropriate for an early adjournment. We shall adjourn today and we will resume tomorrow starting from 9 a.m. May all parties and the public be informed. Security guards are instructed to take the accused Ian Sari back to the detention facility and have him return to the holding cell downstairs where he can participate remotely with the linking of the audio-visual means. The court is now adjourned.